Good day, esteemed viewers. My name is Newness, Oyelade, an undergraduate intern at HARLEM solicitors and a student of Ajayi Crowther University. Today, I'll be taking you through the general duties of a telecommunications licensee. But before we begin, permit me to digress to the definitions of certain terms sacrosanct to the aforementioned topic. What is a license? A license is a permit granted by an authority to own or use something, do a particular thing, or carry on a trade. Examples of licenses we are most likely familiar with include driver's license, hunting license, gun license, copyright license, etc. What then is a licensee? A licensee is any individual, business, or organization that has been granted legal permission by another authority or entity to engage in an activity. Licensing therefore involves obtaining permission from a company or authority, often referred to as a licensor, to manufacture or sell certain goods or products or render certain services. What is telecommunication? The term telecommunication was coined from two French words, tele and communication. Tele means at a distance, while communication is the impact and exchange of information by speaking, writing, or other medium. It was in the 1930s that telecommunication became a global term. Telecommunication, therefore, is the transmission of information by various types of technologies over radio, wire, optical, or other electromagnetic systems. What then is a telecommunications license? A telecommunications license is a license granted by an authority to a telecommunication operator to own, operate, or provide communication services within the scope of their license. It is therefore illegal for any entity or authority to operate a network facility or provide communication services in Nigeria without a license. The body in charge of granting licenses to telecommunication operators in Nigeria is the Nigerian Communications Commission, which is the NCC. This commission is backed and regulated by the Nigerian Communications Act, the NCA, which was established on the 8th of July 2003 under the then President Chief Olusegun Obasanjo. It should be noted that without the Nigerian Communications Act, the Commission and service providers will operate haphazardly, and this will be to the detriment of the economy, as telecommunication is a critical national infrastructure. Nigeria is Africa's largest ICT market, accounting for 82% of the total number of telecommunication subscribers in the continent. This is so because of the various telecommunication companies we have in Nigeria. The relevant telecommunication companies in Nigeria include MTN, Nine Mobile, Globacom, and Airtel. These companies have an obligation to comply with the terms and conditions of their license, as well as the provisions of the Nigerian Communications Act and its subsidiary instruments. Non-compliance may result to the suspension or revocation of such service provider's license. So the duties of a telecommunication licensee. One of the duties of a licensee is the duty to prevent the criminal use of its network facilities and services. The Nigerian Communications Act imposes an obligation on service providers to ensure that their network facilities and services are not used for the commission of any crime or facilitation of any crime under any law in operation in Nigeria. In this respect, Section 146 subsection 1 of the Nigerian Communications Act of 2003 provides that a licensee shall use his best endeavor to prevent the network facility he owns or operates from being used in or in relation to the commission of any crime under any law in operation in Nigeria. Apparently, the duty of care established in Section 146 of 1 of the Nigerian Communications Act implicitly entails that a licensee would have to adopt necessary measures, including the deployment of relevant technical measures to ensure that their network facilities and services are not used for the commission or facilitation of any crime under any law in Nigeria. For example, this duty will entail that a service provider should report any suspicious activity in relation to the use of its network facilities and services for the commission or facilitation of any crime under any law in operation in Nigeria. It would also entail that a service provider would have to obtain relevant identifying information from its subscribers. This is to enhance investigation in case a crime is committed using a particular network service provider's facilities or services. This duty of care also provides that a licensee should not commit any offense or crime using their own network facilities and services. For instance, a licensee will be in breach of this duty of care if that particular licensee prepares or transmits any information that is classified as indecent or subversive under Nigerian criminal laws. Another duty of a telecommunication licensee is the duty to assist law enforcement authorities. The Nigerian Communications Act imposes the duty of care on service provider to comply with lawful requests by the Commission to assist the Commission or any other authority in preventing a crime, investigating a crime, or protection or preservation of national security. In this respect, Section 146 Section 2 of the Nigerian Communications Act provides that a licensee shall, upon lawful request by the Commission or any other authority, assist the Commission or any other authority, as far as reasonably necessary, in preventing a crime, the commission of a crime, attempted commission of a crime, or otherwise in enforcing any of the Nigerian laws, including the protection of public revenue and preservation of national security. To this respect, this implicitly implicitly means that a licensee shall, upon any request by the Nigerian Communications Commission or any law enforcement authority, would have to provide relevant data of a subscriber to them. Moving on, does this mean that any individual can walk up to a service provider to request the information of a subscriber? No. In this respect, Regulation 7/1 of the Nigerian Communications Enforcement Process Regulation of 2005 provides that such request to provide the communication data or information of a subscriber would only be lawful if such request is made in writing and is duly signed by an officer of the Nigerian Police Force who is not below the rank of an Assistant Commissioner of Police. This explains that not just an individual can request the communication data of a subscriber. Conclusively, I'll be talking about limitations to criminal liability under the duties of a telecommunications licensee. Now, a licensee or service provider that has failed to comply with the terms and conditions or provisions of Section 146 of the Nigerian Communications Act would be liable to an offence under the Nigerian Communications Act. However, a licensee who has fulfilled all these obligations would be exempted from any liability which may arise from any act of omission which was done in good faith while performing these obligations. Nevertheless, it should be noted that this exemption does not apply to a service provider in civil proceedings. This means that a service provider is not protected by any law in case a civil proceeding is brought against such service provider who has fulfilled all these obligations in good faith. Consequently, there is a need to review Section 146 of the Nigerian Communications Act. This is because the non-existence of such exemptions will restrain network service providers from fulfilling their obligations under Section 146 due to concerns over fear of litigation or being sued by a subscriber who has been affected. For more information or videos like this, subscribe to the YouTube channel you are watching from. Visit the firm's website at www.harlemsolicitors.com or visit the NCT website. Also, follow Harlem Solicitors on Instagram and LinkedIn. Thank you very much.